Okay, we're gonna get started right away, I guess. So welcome back. We hope you all enjoyed yesterday's program. It was a great program, and we are going to get right onto our program today. We want to do a little bit of housekeeping first. Again, we are recording this meeting, so please keep your microphone on mute. We're taking questions via the chat function at the bottom of your screen. To be answered at the end in the order they were received. So if you have questions, go ahead and put those in the chat and we will keep track of them and then ask them at the end of each session. We'll also take questions live, barring any time constraints that we have, and there will be time at the end of this program for further questions. The handouts are going to be posted to the chat and they will also be sent out via the survey this afternoon. If you can't get the handout from the chat for some reason, please email rachel@newlevelmanagement.com or reply to your event confirmation email. We will post the link to the PDF version of the CAI Nationals Board Member Toolkit into the chat for you as well. But once again, we are not following this book because it is something national put out and we have California specific information for you. So our handouts will have the California specific information. We are going to once again try to get a lot of information into 2 hours. If for some reason we run a little bit over and you've got a hard stop at 11, then it is being recorded and will be posted to YouTube, so you will have access to it. So our next session is governing documents versus new legislation, legal authority for your association. It's being presented by John Hansen of Baydaline and Jacobsen, Deon Stein of the law offices of Deon R. Stein, and Mike Kennedy of Berding, Weil. So thank you guys for being here, and I'll let you take it away.
Thank you, Jennifer, and for Rachel for getting us set up this morning, and good morning, everybody. We're going to be talking about governing documents versus actually legislation in general, not just new legislation. And the purpose of today's discussion is to discuss the role of your governing documents and then when the civil code will actually supersede your governing documents or override them. We'll be going through first governing documents, explaining a bit about those and what they are. And then we'll go into a list of times when the civil code will actually supersede your governing documents and important things to be aware of. The next session right after this one, starting at 10 o'clock, is going to be the question and answer session, or the Ask the Attorney panel. So any questions that you have, you can put them in the chat. And then Rachel will be keeping track of those, and they'll be presented at the next session at 10 a.m. where all three of us will come back, as well as a couple other attorneys, to answer your questions. So just stay tuned and we'll get to those questions. Michael now is going to talk to us about an overview of CIDs in general to give us a baseline to start with.
Yeah, thanks, John. First of all, I saw my mom on here. Hi, Mom. So generally speaking, there are about 50,000 HOAs in California, I believe, and there are different types of HOAs. Some are traditional condominium projects and townhome projects, and then there are groups of single-family homes that are also an HOA, commonly referred to as a planned unit development or a PUD. The main distinction to keep in mind is that in a PUD or a group of single-family homes, all of the members, homeowners, have the obligation to maintain their home, and the HOA manages any common areas, streets, if there's a community room and a pool, that sort of thing. And in a traditional condominium, the HOA manages the buildings as well, because those are also common areas. So the distinction is between the unit, or what the member owns and is responsible to maintain, versus what the HOA owns and is responsible to maintain. And those are different in different types of communities. This is all governed by the civil code, sometimes the corporation's code in some instances, and your governing documents. So there's the documents that set up the HOA, which is a type of corporation to begin with. And then there are the documents that govern the HOA as it's moving forward. We'll get into a little more detail about that, but it's generally the articles of incorporation form the corporation, and then you have your CC&Rs, your bylaws, and your rules and so forth. This sets out what the rights and obligations are between all the parties involved. There's the developer initially, but there's law that says the developer also has rights and obligations under the CC&Rs, even after they're no longer involved, after they've sold the last unit. And this can have to do with the right to enforce some of the provisions around construction defect cases and so forth. But at the beginning, their obligation is to set up the corporation HOA correctly, make sure it's correctly funded, set up for future funding through the reserve study, and that it's off to a good start. And the owners have rights and obligations around what the association owes them, their right to review documents, their right to see what the board is doing in an open board meeting. Their obligations are typically spelled out somewhat in the CC&Rs, also in the rules, as far as architectural standards and maybe behavior around common areas and swimming pools and tennis courts and stuff. The board members' obligations are fiduciary in nature to the membership, because the board members are managing the members' assets in a sense. The board members are running the HOA, and all the members have ownership in the HOA by virtue of their ownership of their home or their unit. And then that's a fiduciary responsibility, which is a little higher than like a contractual responsibility. And so board members are really obligated to follow the civil code and the corporations code and the governing documents. Those sort of form the boundaries within which the board operates, and can make choices within those, but can't really stray outside the lines of what they're supposed to do under those authorities. The board has officers. There's a president, a vice president, and a treasurer. They all have different responsibilities. The ability to call meetings. The treasurer is supposed to watch the finances in a little bit higher sense than the other board members. The secretary makes sure that the minutes are kept and the records are kept properly, although that's often delegated to your community manager. The board can form committees, and we'll talk a little bit about the different types of committees and what committees can do. And then you have a community manager most times that helps the board run this, select vendors, take care of some of the paperwork, preparing budgets and the minutes and so forth. The manager's duties are spelled out usually in the contract between the association and the management company, and their duties are owed directly to the association. That's not usually spelled out in the governing documents nearly as much as the contracts between the management company and the association.
Great, thanks, Mike. I'm going to jump into an overview of what a CID is from a sort of organic standpoint. It's a very unusual animal. It's a very unusual setup. It's four things at the same time. And so as board members for an HOA, not only are you wearing your board member hat and your owner hat every time you're on the board and you make a decision or you do anything within the association, but you're also wearing sort of four different uniforms. The first one is a corporation. Almost every homeowners association in California is set up as a nonprofit corporation, nonprofit mutual benefit corporation. There's a couple that aren't, but for the purpose of this conversation, you're all corporations, nonprofits, and that means you're governed by the California Corporations Code in addition to all of the other statutes that we're going to talk about today. Corporations come with corporate formalities. You have to do filings with the Secretary of State's office every year or every other year, depending on the type of corporation you are. You have to follow the internal formalities, like how you hold meetings, how you run elections, how you provide access to records to members and to directors, and all of those formalities are corporate in nature, and they apply to every corporation in California. You run by a board of directors, and you have officers that discharge certain functions on the board, but that's your corporate function. You're also, at the same time, you're a business. Yes, we're nonprofit, so we're not trying to make a profit, but you're nonetheless a business. You collect assessments from your owners, typically every single month, and a lot of assessments from the owners. You put that money into, you spend it on operating. You put some of it into reserves for long-term planning needs. You have accounts payable that you have to pay as a business, all of your utilities, all of your maintenance and landscaping, all of those. And you have to follow your accounts receivable, people who don't pay their assessments. That's like every other business that does. You have some personnel issues. Sometimes you're a large enough association where you actually employ personnel. Other times you have management personnel, which lead to some of the same kinds of labor and employment issues as just regular for-profit businesses. You have to file tax returns every year. You have to keep financial statements. You have to prepare budgets. So all the business stuff that you would think of if you were IBM or whatever, you guys have to do, no matter what size your HOA is. You're also a real estate project. You're a nonprofit corporation that's sole goal is to manage this real estate project, which means all kinds of things. It means you have property maintenance obligations, you have architectural control obligations, you are governed by recorded documents, the CC&Rs that we'll talk about in a minute. You have bylaws, you have all of those documents. You also have to deal with easements, sometimes easements in the documents, easements created by separate documents. You have to deal with what's in people's deeds because it's real estate in nature. And your membership is made up of owners, and those owners rent their properties to the tenants. And because it's a real estate project, you don't get to decide who buys and sells within the development. So you take your owners as they come, and you don't get to decide who an owner rents the unit to. So you take the tenants as they come. So you have to deal with all of those landlord-tenant related issues. You're not the landlord, but you have to deal with those landlord-tenant related issues. Finally, you're a community. A lot of the industry now is moving towards calling us community associations instead of homeowners associations. But you're a community. You're a group of people made up of neighbors. You're extremely unique of all the other corporations we talked about. You're the only corporation, HOAs are the only corporation that are defined by the fact that you're all your neighbors. That's everything else is a totally different thing. And you have to deal with, like I said earlier, not only the owners in your community, but the non-owners, the tenants and the guests. And it's a very difficult process to keep all of those interests. And this is my favorite word of the entire seminar, balance. Your job is to balance the interests of the corporate interests and the business interests and the real estate and the community and the tenants and the landlords and the owners. The balancing act that board members do is the most careful dance that you have to do on anything probably in your business world, because everybody feels that their interests are the only interests that matter. And so that's our weird four-headed monster here. And that's sort of a basis for John.
Well, there's really four types of communities in California that constitute a common interest development, but we're going to describe them a bit differently here. There's a stock cooperative, very uncommon, often occurs with lower income or lower price point housing, often with mobile home type developments. There's a condominium project, very common in California, where owners own their unit in a larger building with multiple other units. Planned development. Owners own their land, and the structure on their land could be either separate detached structures or townhomes. Then there's mixed use, much more common we're seeing in California, where you have both commercial and residential merged into one. Maybe it's commercial on the bottom, residential on top, or a variety of combinations. And then a master association or a larger planned development that may have a sub-associations or smaller associations within it, or a combination of single-family homes and condominiums, but a variety of types of communities that common interest developments can consist of all shapes and sizes.
The types of legal documents that govern these associations fall within the same categories, but different between the type of community that you have. Almost all of them will have a declaration master deed or CC&Rs, most commonly the CC&Rs, and that kind of governs what the association does and doesn't do, that builds upon the requirements, the basic requirements that are in the civil code. So that will set up some of the important things you may see if there are variations in the maintenance responsibilities for different components of your association, vote requirements for an assessment or special assessment, or taking out a loan and so forth. It'll spell out the election cycle oftentimes. Sometimes it'll say how often the board is supposed to meet. The provisions in the CC&Rs are pretty important because, as I mentioned earlier, that sets one of the boundaries the board has to operate within. The articles of incorporation are the document that essentially forms the HOA/corporation at the very outset by the builder developer. Those are often usually done before the project is even built. It sets out what the official name of the HOA is and when it was formed. And other than that, it doesn't really affect the day-to-day operation of the community nearly as much as the CC&Rs and the other documents. The condominium plan for a condominium project is very important because it delineates exactly what that, and the subdivision map delineates exactly what is common area and what is separate interest, either the lot in the case of a planning and development of single family homes, or what's the unit in the case of a condominium plan. It's theoretically possible to change that or amend that to grant common area to a unit owner, but functionally it's nearly impossible. And if you're thinking about that, work with your counsel to talk about the details of that, because it's, as I say, very, very difficult. The bylaws govern essentially the board and how it's supposed to operate, who the officers are, and so forth. It works in conjunction with the CC&Rs. Amending both of those is easier than amending the condominium plan, but requires a vote of the membership and all the formalities that come with that, hiring of an inspector of elections and so forth. Govern really the day-to-day operation or month-to-month operation of the HOA. And then you have the rules, regulations, and resolutions, which are board decisions to form, usually don't require a vote of the membership, and therefore are easier to amend, but they can't change anything in the bylaws or CC&Rs or articles or anything in the list above. And so rules will typically govern, you know, architectural standards, parking rules, solar rules. You may have rules around what it takes to rent, or requirements to rent out one of the homes or units and so forth. And a little bit later in the presentation, we talk about the hierarchy of these different authorities and what happens if they conflict with each other. I think one of the important things to do for a newer community is to make sure that everything syncs up, the CC&Rs and the rules and the reserve study and so forth, because they don't always match each other at the outset. And that's sort of an overview as a developer hands over control to the membership. But those are the basic governing documents that work in addition to the civil code.
So a couple of highlights about the CC&Rs. If you're looking for a sort of an analogy, we tend to think of the CC&Rs as the constitution of your organization. It's a little different than the US Constitution in sort of many ways, but it's sort of the granddaddy of your governing documents. It's the document that's recorded by the developer before the developer sells any lots or units in the development to any member of the public, and that document has to be recorded before it's sold. It's a public document, so you can go down to the county records and get a copy of the document. It's a legal contract. It's binding as a contract. It binds all the owners to each other, and it binds all of them to the association, and the association to all of them. It can be amended. It is not a static document. It's about as hard to amend as the US Constitution. So that's probably why it's a good analogy. And it should be hard to amend. It should be a difficult document to amend. The Davis-Sterling Act says it can be amended either by whatever is said in the document, follow what's in the document, or if the document doesn't say how to amend it, then at least a majority of the owners can vote to amend the document. And then we have some documents, some CC&Rs that have what we call a supermajority amendment requirement. Anything over a normal majority, so 60%, 75%, something high up there. And the legislature has recognized how hard it is to get 60% or 75% of people to vote yes on something. And so there's a court petition process for amending CC&Rs with a majority. If you don't get a supermajority vote, as long as you can get a majority vote, you can go to court and try to persuade a judge that your amendment is reasonable, and the court has the authority to approve it. So there's a sort of what we call a safety valve for these supermajority provisions. So that's about it for CC&R highlights.
Then we have a document called a subdivision map or a condominium plan. And these are often neglected, forgotten documents that every development has. For plan development, every development has a subdivision map, and condominium developments have subdivision maps. And then for condo developments only, they have this condo plan. The subdivision map is a recorded document that is a two-dimensional document that subdivides the land. It cuts up a piece of land into lots or parcels, common area, public roads, and things like that. The condominium plan for a condominium project only is a three-dimensional engineered plan that shows where the units and the common area is on the actual buildings. It's a recorded document. It's often submitted by the developer with what's called the white paper. That's HOA jargon for the Department of Real Estate public report, where the state actually approves the development. It can be a useful document to make sure that you always have and you're always aware of, because it can often clarify association or owner responsibility for things like maintenance, easement rights, where a property line ends and when begins. You can often find a lot of detail in those maps. I'm working on a situation right now where there's a gate on the backside of a development that the board wants to close off. Well, it turns out it was dedicated as a public easement that's meant to provide public access to a shopping center on the other side. So those maps can really have a lot of detail. The condo plan also can be really important with defining condominium elements, like, is this fireplace a part of the unit or is it a part of the common area? Well, that'll often be shown on the condominium plan, or who maintains a particular pipe could be shown on the condominium plan. So they can have some relevant information that can supplement or clarify the CC&Rs.
The articles, as I mentioned earlier, is the document that essentially forms the corporation at the very beginning. That's done before the project is built, before it has any members. It states what the corporate purpose is. Typically, they'll say something, sort of vague to give the developer room in case they want to change exactly what they're doing, but they're going to say the purpose is to create a common interest development. It'll say exactly what the name of the HOA is. So the legal name of your association may be a little bit different than what you call it, or there may be some shorthand. The CC&Rs may have a name that's slightly different than what's in the articles of incorporation, but what's in the articles is the official name of the association. And then at the beginning, it will say who is the agent for service of the corporation in case there are any legal processes. Now, that's very easy to change. Most of the time, your community manager is the agent for service once the association is up and running and turned over to member control, but the initial agent is set out and what's in the articles. And it's filed with the Secretary of State. So some of these documents we're talking about today are easy to find. It's on the Secretary of State website. There's a search function. It takes 2 seconds to find it. Some are recorded and some are just held by the association. And keep in mind, all of the members have a right to get all of these there's a list of these records in the civil code from the association itself, but this document's very easy to find. It can be amended. It would be rare to need to do that because, again, it doesn't really govern the day-to-day operation of the association. It's just the document that forms it at the very beginning.
Mike, if I can jump in there real quickly, if you can go back just on the amended part. It's very rare to have to amend your articles these days, but if anybody on the call here is with an association that was formed prior to 1980, there was a big change in the Corporations Code in 1980, and it really affected articles of incorporation. And if you are one of those pre-1980 corporations and you haven't yet amended your articles, call your association's attorney and get them. It's an easy amendment to make, but you have to make it. And so it has to do with, what happens to the assets of the corporations in the event of dissolution. And so that's the only time where I think you really need to double check and go back in time.
Yeah, thanks, Deon.
Okay. Bylaws. This is the non-public document that Mike was talking about. It's the one that's not recorded. It's a very crucial document. It's your internal operating rules. It's how you do elections and voting and notices of meetings and the number of directors and the qualifications for directors. All of that stuff is typically in the bylaws, mostly based on information in the California Corporations Code, somewhat these days, Davis Sterling as well. But if you can't find your bylaws, there's no public repository for you to go and look for these things. It's very frustrating. So sometimes we've gotten contacted by a new client, and I'm sure John and Mike's the same way, and they say, we don't have a copy of our bylaws, where do we get them? And you kind of have to scramble and go back to the prior management, go back, you can go as far back as to the developer. A lot of us attorneys in the industry have relationships with the developers and the developer lawyers, and they'll go and pull their files. You can even go to the Department of Real Estate, and if they haven't destroyed that file yet, they'll pull out the original articles, bylaws for you. So they are findable generally, but they're not a public document. It talks about the powers of the board. It has limitations on the board's powers often, and all of the internal stuff. And again, amendment is governed by the terms of the bylaws. They'll tell you when and how they can be amended.
Next, we have our rules and regulations. And the rules and regulations are an extension of the CC&R's bylaws and articles. They're adopted by the board, not by a vote of the members. And they need to be consistent with the CC&R's and bylaws and articles. So they typically will put more meat on the bones. For example, the CC&R's may say that you must get architectural approval before you can change your home. And then the rules will say, and here's the things you can do. Here's the paint colors that you're allowed to do, or here's the types of architectural designs. They can govern use of the common area, like how many guests you can bring to the clubhouse, or not having glass bottles by the pool. You can have all those additional details that are created through your rules and regulations. And it can often be a way to deal with something without having to change the CC&Rs. For example, I got a call yesterday from a new association that said, hey, we have a homeowner who's been breaking the rules and we never had this problem before. We want to amend our CC&Rs to be able to start have fines that we can impose against them. I said, well, you can actually do that through a set of rules. Just send me your CC&R so I can go through them, but we can likely just adopt an enforcement policy and a schedule of fines and accomplish that goal without an expensive and lengthy CC&R amendment process. The same thing can occur with other nuances like, again, architectural control, some little things that you can do that will help give you more detailed specifications or regulations without having to go through the process of amending the CC&R. So a useful document that can be really help govern your association.
Sometimes you want it easier to change. As we talked in our prep call, if somebody calls us and says, we want to amend our CC&Rs, our response is often, well, why do you think you need to do that? Why can't it be a rule? Because that's much easier to do and easier to change later. I have an association where the fine schedule is baked into the CC&Rs, and there's a certain type of violation that's like $100 per violation because it was written in the 1980s. And so people violate the rules and write a check for $100, and the board would like to up that, but it's pretty major surgery because it's baked into the CC&R. So being a little more flexible with the rule is to your benefit.
Yep.
So the resolutions and minutes. So the minutes are kept in the board meeting. It is the record of what the board did and decided in the board meeting. So typically, well, officially, that's the responsibility of the secretary of the board. It's typically done by your community manager. And that's the official record of what happened in the meeting. So if somebody else took notes or somebody else remembers something else happened, or somebody without authorization recorded the Zoom meeting of the board meeting, that's not the record of what happened in that meeting. The minutes are. And so it's important, I think, to be fairly detailed with that, of exactly what the board considered and what the board decided in that meeting. Sometimes if there's a controversial decision made in a board meeting that you think a member may challenge later, it's a benefit to record the vote. This board member voted yes, this one voted yes, this one voted no, and it passed, 3-2. So you can reconstruct later during a challenge exactly, what we did and who voted for it, and I voted against it, and that's your official record of what happened. You would also record the formation of committees that delegate some of the board's authority to a committee. Commonly, it might be an architectural committee or a landscape committee. If there's litigation, enforcement of the governing documents or construction defect case, you can form a committee to manage that issue. And that's beneficial because you don't need the formality of a board meeting to make every decision. If you're changing the landscaping in the community and you want to form a committee to work with the landscaper, they can meet, weekly or as needed without all of the advance notice and publication of an agenda and the formality of a board meeting, and be a little more nimble to deal with issues that come up. But if you're forming a committee, think about and record what type of a committee is. And I don't just mean, is it an architectural committee or a landscape committee, but is it advisory or executory? If it's executory, the board is delegating authority to this committee to make decisions. Well, how much authority and what decisions are you delegating to this committee? So that means drafting a resolution or a charter. We're forming this committee. Here's what their authority is. Or the committee could just be advisory. The committee is delegated to go collect bids from landscapers and report back to the board at the next meeting. Please go get 3 bids and, you know, recommend which one you recommend, and then the board will make the decision. So record that with a resolution or a charter when a committee is formed, so that again, you can reconstruct later what authority does this committee have in case they exceed that authority or somebody wants to challenge a decision that the committee made. These are all a corporate record. If the minutes say something happened, the evidence code says that there's a presumption that that is what happened. And so these are, again, it's to reconstruct what happened later if there's a challenge or you've got a new board, you know, years later, you've got different management, a different board. Nobody remembers what happened at that meeting back in 2015. You go back and pull the minutes. Every member has a right to get the minutes, except for what happened in executive session. Those are confidential proceedings. But that's the record of what happened in that meeting that anybody can examine later.
And it's great that we have a presumption that whatever's in the minutes is what actually happened. But there's also a corporations code provision that says it's a crime to falsify what's in your minutes. So you don't get to just rewrite history because you feel like it. But if you write it accurately, it's pretty much gold. So
yeah, don't do that.
Yeah. So now we get to sort of the intersection between statute and all of these governing documents. All of these governing documents have rules, restrictions, statements, parameters, all these kinds of things. And then we have the law that comes along, Davis-Sterling primarily, but also the corporations code. And they say something different than what's in our governing documents. Which one do we follow? People obviously want to follow the one that helps them the most. So people will throw the statute at us and say, see, the statute says this, your governing documents are out the door. Or look, the governing documents say this. Davis-Sterling of the statutes don't always supersede. They usually do, but not always. And how you determine it is you look at the language of the statute, and the language sometimes says, here's what the rule is, no matter what your governing documents say. And that supersedes every single time. But sometimes the statute says, here's what the rule is, unless your document says something different. Then you have flexibility to say something different and the governing document will control. Or the statute will say, here's what the rule is, your governing document can say something different, but only within these parameters. Then you have flexibility within those guidelines, but outside of it, the statute has the outer walls on that. We saw that just in the last year or two with the rental restrictions and the rental caps, that we can't go any lower than 25%, but we could have a 30% one if we want. We just can't have a 22% one. And then sometimes the statute's just silent. You know, it says, here's the rule, or it doesn't say anything at all. And then you have to figure out, what did the legislature intend, supersede or not supersede? So we're going to go through those provisions of mostly Davis-Sterling. There's a couple of other ones, but mostly Davis-Sterling, where the statute controls no matter what your CC&Rs or your other governing document says. So we're going to start with John, starting with some Davis-Sterling stuff.
No, it's not always as simple as the law says this is the way it goes, so that's what has to happen, and there's complexity in it. So the starting place is that the Davis-Sterling Act says, when it comes to the hierarchy of authorities, you have the law, then your CC&Rs, then your articles, your bylaws, and your rules. So whoever's on top, if there's a conflict, the one on top controls. But what is often the case is the law may say something, but it doesn't say that the CC&Rs can't be stricter. So you have to always do an analysis. A simple example is I have a person right now who has white rocks in their front yard. CC&Rs and the rules say no white rocks. The local city says during the drought, you can install rocks in your front yard. So he's saying, how dare you stop me from allowing from my white rocks? The city said I'm allowed to have rocks in the front yard because of the drought. We said, yes, we actually allow you to have rocks, but we don't let you have white rocks. You can have colored rocks. So there's all these different nuances that you have to keep in mind when you're going through the law versus the governing documents. One thing that the law always stands on is notice. The law generally controls when it comes to notice when you're doing general notice. And what the law says is general notice is the type of notice used for certain types of information you give to homeowners when it comes to changing rules, board meeting notices, calls for nominations in the regular election process, not in the acclamation process. That's a bit different. Unless a member makes a request in writing for all posted notices to be mailed to them. So this is going to be our baseline notice requirement for how we give notice by posting it in the designated location in the common area, or now on a website when you're giving notice of certain types of activities. So that's kind of our baseline that we work from when it comes to notifications. The Civil Code also states that the governing documents are to be liberally construed to accomplish their objectives. So when there's some vague language in the CC&Rs, you can go to what's the intent of this section? What's the intent of this parking restriction? Is it meant to keep cars off the street or cars off the driveway? The law is going to give you that broad interpretation to meet the goal of that. So that's also where we can get, sometimes the law is going to give us a different direction than what maybe the plain language might say in a CC&R section.
So there are several of these. The top three on this list are all constitutional First Amendment issues, so they're pretty inflexible. The first one is Civil Code Section 4515 is a free speech issue. The biggest issue, I think, is that allows members to use common area to gather and discuss issues related to common interest development living, recall elections, political issues. If they want to use the clubhouse, then they get to use the clubhouse to talk about these types of issues if it's not otherwise in use, and any restrictions have to be reasonable. The association can't require a deposit or charge them part of the association's insurance or collect any fee. If they want to gather and talk about an issue related to their HOA or any political issue, they get to, if that common area, typically the clubhouse, is not otherwise in use. And so if you have a reservation policy and someone else has reserved it for a birthday party, then that's a reasonable restriction and the clubhouse is not available that day. But other than that, if they want to get together to collect signatures for a recall election, you may not like it, but the association has to allow it. Similarly with social media, and this is a big issue, people get together and complain about what you board members have done in the Facebook group or on Nextdoor. The association cannot restrict that. So it's not in this section. I personally think it's a bad idea to chime in and argue with them on social media if you're a board member. But if they want to get together and discuss issues around the community or things that they like or don't like on social media or in person in common area, they're absolutely permitted to do that. The next one on the list here, there's two Civil Code sections, is that the association cannot prohibit signs or flags as long as they're for non-commercial use. So we've got a presidential election coming up in the news. If people want to put up their Trump or Biden flags or Black Lives Matter signs or whatever non-commercial signs and flags in their yard, then they're allowed to do that. That's a free speech issue and the association cannot restrict that. Commercial signs are different. If they want to put a sign for their business or something, you can restrict that, but any non-commercial sign or flag cannot be restricted. Similarly, religious symbols are permitted. Now they can attach it to the door, but not the wall. That has to do with, if somebody wants to put up a nail and hang their religious symbol on the wall of their unit, now they may have damaged common area by breaching the waterproofing of the wall and creating a leak that's going to cause damage when it rains. But if they want to hang a religious symbol on their door, they're permitted to do that without regard to their religion, obviously. And those are all big First Amendment issues. There's no flexibility around that. The first two, there can be reasonable restrictions, but what's reasonable is going to be looked at with a pretty close eye by a court in any challenge. 4715 allows them to have one pet. It has to be a domesticated animal, no pet tigers, subject to, again, reasonable restrictions, right? So you can't have a pet horse in a 1-bedroom condominium, even though it may be domesticated. But you can't have a no pet policy. It tempts me to want to launch into my tiger story. The time a friend of mine was a manager of a high rise in San Francisco, and somebody brought a tiger into a building. And there was a call in the middle of the night. Somebody brought a tiger into the elevator. What do we do? And we did not have a tiger policy in place. But anyway, those are all very important issues that the association has to be careful not to infringe, because that's big trouble.
On this slide, the first 4 of them all fall into a category of public policy with respect to environmental issues. And so 714, which is not part of the Davis-Sterling Act, but it is still part of the California Civil Code, and 4746, which is part of the Davis-Sterling Act, together those implement the California public policy in favor of solar energy. And I think all of us are probably big fans of that. We do like to have some control when people start putting them on condominium roofs, so that, you know, the first guy who wants to put his solar on the roof of the building doesn't take up the entire building, so nobody else has room for their solar panels. So we have limitations and restrictions that we can put on those things, but the general overall push is to allow them and encourage them. Similarly, 4735 deals with the drought issues, drought tolerant landscaping plants, artificial turf, and we'll see more of that, I have no doubt. 4753 was kind of tied to this energy issue too, clothesline in backyards, because people were saying we don't want to spend the money on electricity and we want to dry our clothes hanging on lines in the backyard. And everyone got into a big flap about this about 5 years ago. And then I don't think I've seen a backyard clothesline since then, but it was a big issue and it was fun at seminars for John and Mike and I to talk about. But it really hasn't materialized into much of a big deal. Same for you guys?
Not many clotheslines.
Yeah, not many. Okay, and then the last one is this public policy dealing with the crisis of too little housing in California and encouraging ADUs and what we call JADUs, which is a junior ADU, accessory dwelling unit, a second residence on a lot. And there's a big push now in California to allow and encourage those. And associations' hands have been significantly tied in their ability to, certainly restricted in our ability to prevent it, but also tied in the ways we can limit it. And you know, hopefully this will help alleviate the housing crisis. I'm not hugely optimistic that this is the solution, but we have to deal with that, and it's becoming a real issue.
Next,
John,
we have a series of different topics. First, relating to disclosures. The law generally has very strict parameters on disclosure obligations, and this is seldom going to be addressed in your governing documents. And generally speaking, in a sale process, it is the owner who is selling their property that is solely responsible for disclosures to the seller. The association, though, has obligations to provide information to the owner / seller. Excuse me, the owner is responsible to disclose to their buyer. Then the owner / seller can get information from the association. So it's association to owner, owner to buyer. That's the order of disclosure obligations. Then Civil Code Section 4275, which was mentioned earlier, is this process to get CC&R amendments approved by the court if there is a supermajority approval requirement that cannot be reached. So if your CC&R said you must get 67% member approval to change your CC&Rs, you can go to court to have that reduced down to a majority of all members. Corporations Code 7515 gives a similar process for bylaws. Civil Code Section 4355 and 4360 address the rule change process, including how it's done. If your governing documents conflict with that, the law is going to control as far as the notice period, the process. That's the universe for how you adopt rules. And then Civil Code Section 4600 is dealing with exclusive use common area. So assigning someone the right to use a parking space or allowing someone to expand their patio fence into the common area. Certain types of common area use is going to require member approval, but there are a list of exceptions in 4600 when the board can approve that without the vote of the members. And that's one of those sections that says, unless the governing documents provide otherwise, here's how you do it. And most governing documents will not address exclusive use common area approval. So you're mostly going to rely on Civil Code Section 4600 for that process.
So this first one was a change 4 or 5 years ago, where now the HOA is not responsible for owner relocation costs. And this is the source of a lot of owner unhappiness. So picture the case where there's some kind of a leak, a plumbing line broke and flooded a couple of units, and the owners have to move out while the repairs are performed. It's common area water supply line that damaged the private interest, separate interest units, then the association has to repair all that. And if the owners have to move out, that's the owner's responsibility. Now they'll often have insurance coverage under the separate unit owner's policy for that relocation, but they often want reimbursement, and that's not an association responsibility. And so I think the association can't voluntarily pay for that hotel or Airbnb bill because they feel bad for the people, because that's not an association responsibility, and that would be a breach of their fiduciary duty. So we see that in some sort of damage repair context, typically. Like I say, a pipe broke, roof leaked, repairs after a construction defect case, that sort of thing. And that was a fairly recent change. 4930 ends up being a big deal when people are arguing or unhappy with some board decision commonly during homeowner forum in a board meeting. As you know, during a board meeting, the homeowners have a right to speak about any issue they want to during homeowner forum. And if they bring up something, especially if it's not on the agenda, the board can't take up something. The board is not supposed to engage or argue with the homeowners during the open forum. That's typically a bad idea anyway. I mean, if they ask, for some issue or raise something the board didn't know about, the board can say, thanks, we'll take that up. We'll put it on the agenda for the next meeting. The board now has new information and meeting to act on. That's all fine. But if they're arguing about some decision, something, they got fined and they want to bring it up again, something like that. I had one client where literally every time some homeowner would argue about something or complain about something, the manager would jump in and say, "Are you requesting IDR? No? Okay, thank you for sharing." And that's it. If the board members have a back and forth argument with the homeowners during the homeowner forum, that's just a recipe to have the whole meeting go off the rails, and it's not supposed to happen anyway. So keep that in mind as homeowners are, giving feedback, potentially criticizing things you as board members are doing on their behalf. And then 5605 talks about approval requirements for assessments. There are restrictions on how much you can increase assessments or impose special assessments. This is another reason why it's so important for the reserve study to be accurate, to deal with, so you don't have surprise costs come up. Sometimes the financial obligations of the association change, even though you have a great reserve study. A common issue is for condominiums is this new balcony inspection requirement, SB 326. It's a newish requirement. A lot of associations aren't funded for that. And so you've got to raise the money somehow. That can be a regular assessment. It can be, an assessment increase. It can be a special assessment, but there are restrictions on what the association can do. I think it's 20% for an assessment increase and 5% for a special assessment of the budget without a vote of the membership. If you have to go over that, you've got to go to the members and have them vote on it. There are certain exceptions for an emergency special assessment. An extraordinary expense, if the court orders the association to pay something, that can be an emergency special assessment. If there's some new surprise financial obligation the board couldn't have anticipated the last time you passed a budget, that can be an emergency special assessment. If you do that, though, you have to pass a resolution explaining to the membership why you could not have anticipated this expense, some extraordinary expense that popped up 6 months after you last passed the budget. We could not have anticipated because of XYZ, and that's why it has to be an emergency special assessment. The members are entitled to an explanation of why you didn't anticipate this expense. But that tool is available if there's some surprise expense.
The next two deal with disciplinary hearings. Disciplinary hearings used to be governed only by the Corporations Code, and I'm talking 20 years ago. And the Corporations Code used to say you can discipline an owner and then send them a letter within 5 days and give them an opportunity to request a hearing. That changed about 20 years ago when the Davis-Sterling Act said, no, before you discipline, impose a fine or any other discipline, you must first call the owner to a hearing, give them 10 days notice before you can actually impose the discipline. That changed things dramatically. And then a subsequent change said, you got to give them 10 days notice or longer if your documents require it. I bring this up here to say, if you have enforcement procedures in your governing documents that are older than 15 or 20 years, go back and look at this, because invariably somebody's going to stumble over this and do it the old way. This is one where the law will invalidate any discipline you impose if you didn't give the required pre-disciplinary hearing notice. So that's a very important one. The disciplinary hearing is usually held in executive session. It can be held in open session. We don't recommend it. But if a board wants to hold an open session, this statute 4935 says the owner has a right to demand that it be moved into executive session, and it has to be done in executive session. We generally recommend you do them in executive session regardless, but just understand that an owner has a right to force it into executive session even if you don't want it to be. So that's all I have to say about disciplinary hearings.
Our last two laws before we break for the morning, before our next session, is dealing with elections. Civil Code Section 5105 states that a mandatory qualification to be on the board is that you must be an owner. The only exception are developer entities, which can have a person they appoint on their behalf. But if your CC&Rs or bylaws rather do not require ownership to be on the board, that is superseded. Everyone must be an owner. So no non-owner spouses, no tenants, must be an owner. And then Civil Code Section 5105 states that owners can give a power of attorney to allow someone else to cast their ballot, but does not give them the right to attend meetings or serve on the board. So the power of attorney is only for casting a vote. I mean, you could basically do a proxy anyway, so it seems kind of odd to have that, but regardless, the power of attorney is only for voting, not for going to meetings or serving on the board. That concludes our material for this morning. I know we'll have a brief break before the Ask the Attorney panel comes back at 10 a.m., but thank you all for joining us this morning and for keeping up with us on a lot of content.
Rachel, are we taking a break?
Yep, sorry, we are taking a break. We get a break. This is great. Please come back at 10 a.m. We will have a sponsor on who has a prize for today, so that's exciting. Please make sure to come back at 10. If you want to start putting your questions in the chat, you can. We are putting them into a document. They will be answered in the order that they are received. Again, please make sure that they are not too specific or they will not be answered. Yes, Deon?
Should we log off before we come back, or should we all just stay on and go on to mute and camera off? What's easier for you? Because then you don't have to let us all back in.
No, I'm just going to leave it up.
Okay.
Feel free to talk to each other if you want. However, this is being recorded. So,
Thank you.
Yeah. See you guys all at 10.
How do I lower my hand?
I'll do it for you.
And
Okay.
I got it. Thank you.
Let me remove all the spotlight.
High-end technology. I can't handle it.
There we go. Now you all can see each other.
Okay, I'll be back in a sec.
Problem. We will be back on at 10 a.m. We have a 5-minute break. Thank you for joining us. We will be back at 10, and I will be right back as well. All right, everybody, it is 10 a.m. We are going to be getting started here. I hope you're all back from your lovely break. Never mind about what I sent you, Jen.
Okay,
Never mind. Let's figure it out. I am going to pass it over to Jen, and we are going to get rolling.
okay, welcome back, everybody. I hope you had enough time for a break. We couldn't do any of this program without sponsors that sponsored this program so that we could have you all here today. So I'm going to mention a couple of the sponsors, and we do have one event sponsor here today that is going to have a straw for a raffle prize. So the sponsors for the program today are Laura Angus with Brightview, Brenda Lynch with CID Consortium LLC, Suzette Beck with Real Manage, and Erica Erskine with Cyclone Eco Power Wash, who's here today. So Erica, if you want to come on and say a few words, and then we'll get to your raffle prize.
Hi, can everyone hear me okay? Yes, okay, good. I was having trouble with my speakers. I apologize for that. Welcome everybody, and volunteering is very dear to my heart, so I am very thankful for all of you that give of your time to make our communities wonderful. We couldn't do this without you. So without further ado, I do have a raffle prize for you all today, and we're going to be raffling off a $50 gift certificate to Buca the Beppo. All righty.
Can you see the wheel?
Yes.
Yes.
Okay, thank you. I muted myself. Here we go.
I love the wheel.
Robert Spieler, are you still on with us today? I think I saw him. Let me see. No, Robert Kendall is on, not Robert Spieler.
No, Robert Spiller is on.
Oh, hi. Okay.
I saw his name somewhere.
Okay. Sorry. Thank you, Erica. We appreciate you.
Congratulations, and I'll be in touch with that.
All right, thank you, Erica, and thank you again to all of our sponsors. We ask that you please consider our sponsors when you are planning projects or need help in your community. We will now move on to our last session, which is the Ask the Attorney panel. It is being led by John Hansen of Baydaline and Jacobsen, Deon Stein of the law offices of Deon R. Stein, Mike Kennedy of Berding, Weil, and we are adding Daniel Heaton of Nordberg, DeNichilo, to join our panel of Ask the Attorneys. So this is where you guys get to ask your questions. We ask that you keep them non-specific. If you have specific questions about your particular community, those are best handed to your counsel. But if you have general questions that our attorneys here can answer, they will be happy to do so. So I'm going to let you guys take it away.
One correction, Jennifer, it's actually going to be Darren Bevan of my firm instead of me. I'm just hanging back, but Darren will be the one answering.
Okay, perfect. Welcome, Darren.
Back
Good
to
morning.
you,
Okay.
So how do we do this? Sorry, do you?
No, it's okay. Sorry. I was supposed to step in and
Because I saw some in the chat that were really good ones to get started on.
Yeah.
Right.
Yes, so we do have 3 questions in the queue as of right now. So because this is being recorded, I will be reading the question, and then you guys can decide how you want to answer the question. And then we will be fielding questions on the back end as they come in. So attendees, if you have questions, now's the time to start putting them in the chat so we can start getting them in the queue. Okay, so our first question is, under the statute, can an association allow 1 pet for an owner, but say no pets for a tenant?
I saw that. That's a great question. So the tenant is not a member of the association, is not subject to the CC&Rs usually. I say usually because sometimes, and we've done this for clients, is to create a rental policy that requires the lease incorporate the terms of the CC&Rs, not because of pets, But that would give the association the right to enforce CC&Rs against the tenant. If there's a nightmare tenant that's creating nuisances and causing problems for the association, and the association can normally only go after the owner / landlord who may be innocent of their tenant's bad behavior. So that's outside the context of pets, but in that instance, then the tenant may be bound by the rules and the CC&Rs and the civil code. But normally, no, the tenant's not a party to the contract that is the CC&Rs or a member of the association.
But the question, I think, is the statute doesn't allow us to prohibit an owner from having a pet. Can an owner prohibit the tenant from having a pet? And I think the answer to that is yes. Between the tenant and the owner gets to decide whether or not there's pets. The statute only governs what the association can prohibit.
Yeah, and the question then becomes, can the association prohibit? I think this is the question, that can the association prohibit a tenant from having a pet? So it's not a matter of the landlord-tenant relationship, which I think you're exactly right, Deon. They absolutely could prohibit pets within the separate interest, the lot or the home. But could the association prohibit tenants from having pets?
Or enforce that provision against the owner when the tenant has a pet?
Yeah.
Right.
And I don't, there's no clear answer on that. I think there is some risk to it. The statute says no governing document shall prohibit the owner of a separate interest from keeping at least one pet. Right. And so the question then becomes, is by extension, is prohibiting the tenant in essence prohibiting the owner? And I think that's where you'd run into trouble with the court saying that's unreasonable. To when an owner can have a pet there, the tenant by extension is as if the owner is there. And I think the courts would more likely than not say you couldn't enforce that against the tenant and prohibit pets.
Agreed.
Yeah. I always like agreeing with Deon, so that's good news.
Thank you all. Okay, our next question. Can owners who make comments in open forum be identified in minutes by name, address, and their comments?
Or a better question, should they be identified? Right? I think you could always identify owners who made comments during the open session, but then the question is, yeah, you can, but should you? Right? Yeah. The minutes are what? I mean, Deon, how would you define minutes?
Well, so the minutes are supposed to be a permanent record of the actions taken by the authority that had the body that had the authority to take action at that meeting, and normally it's the board meeting, the board at the meeting, and enough context for you to understand why they did that. I don't think owners' open forum comments should be in the minutes at all. I would not only would I not identify them by name, but I wouldn't even try to summarize their comments. I would simply have the minutes record that an open forum was held, so we met the statute, and members were given an opportunity to comment to the board. The problem, the reality is the people who speak at open forum most of the time are people who are angry and want to criticize something. And the minute you try to summarize what some angry person said, you just make them more angry because you either misspeak on their behalf or you didn't show as much anger as they wanted you to show. And you just tick them off even further by trying to summarize what they say, or you don't capture everything they wanted. So my feeling is note in your minutes that an open forum was held and that members were given the opportunity to address the board. That's how I would do it.
Yeah, and it creates all, like Deon said, it creates all sorts of risk. And the other problem you could run into too is misspelling names, insulting people in that way, not correctly identifying what's been said. And like you say, the whole purpose of minutes is to document the record, the actions of the association's board as the governing body, not necessarily what comments were made.
And I'm going to piggyback off of one phrase that Deon said, that it needs to be in context. And I think that goes even further than just the homeowner sections. We have clients every once in a while that like to do a line item, you know, director said this, as they're discussing between the directors about actions. And you don't need that. You don't want that inside your minutes. Like the two have said before, this is enough context to decide what was discussed and then the actions that the board took.
You guys are good. I was gonna give a lawyer answer and just say, it depends.
No.
We just answer that for all of them and then walk out.
Yeah, well, but it kind of does, I think, in this context, if the homeowner raises their hand and says, you guys are removing my favorite tree, I wish you wouldn't do that. There's really not a good reason to record who said that exactly in the minutes. But if somebody raises their hand and says, hey, you guys towed my son's car last week and I'm not happy about it, I want IDR. Well, maybe that's something that could be recorded in the minutes to record that they did, that happened. That's an official action. Now you have to grant them IDR. And so that's not a bad idea to record in the minutes, I think. So it kind of.
And the other part too is, remember, keep note. You can always keep notes, right? I attend many board meetings. I keep notes on who's made comments, but that's not to go into the record of the association. It's just for my own reference. And I think either the manager or the board can easily take notes on those points so they can remember, who was it that was so upset about the tree removal, or who was it that said this about, I want to have my tenants have lots of pets. There's always an alternative to minutes, right? And that is just keeping good notes and keeping good records so that you can remember what was said during the open forum without actually documenting or misstating what the members are saying in the open forum.
Funny, when John and Mike and I were preparing for the previous seminar, the one just an hour before, and we got to the one slide that talked about minutes, and we said, boy, we could do an entire morning seminar on nothing but minutes.
Yeah.
And probably on every one of those topics, we could have done a whole seminar, but minutes particularly, we get so many questions about minutes. And the funny thing is, David Sterling says virtually nothing about what they should say, how they should say them. All it says is you got to keep accurate minutes. And if you falsify minutes, that's a crime. That's about all the statute says.
Corporations code mirrors the same provisions, right? You have to keep a record. It says even less about, it doesn't even reference minutes, it just says you have to keep a record.
Yeah.
So it is within the discretion of the board what that record is. And if you have questions, obviously consult with the association's attorneys to figure out what is the best strategy for your community.
All right, thank you guys. Our next question is a bit long, so if you need me to repeat myself, please let me know. How should the board handle owners that attend an open meeting or send in an email and question board decisions if the board cannot engage in discussion with the owner during open forum?
Well, the board can engage with an owner during open forum. They can communicate with the owners. A lot of folks will say, a lot of attorneys will say, well, don't respond or don't get into fights. And I'd agree with that statement. Don't get into fights with members during open forum. But you can respond reasonably to questions asked if it's just a question or informational request. There's nothing in the Open Meeting Act that prohibits that. As a matter of fact, that in many ways it encourages it. We can respond to questions.
Yeah, you can't make a new decision on a new issue somebody raises because that wasn't on the agendas. But here's exactly what the statute says is a director, managing agent, or agent of the board may briefly respond to statements. You can give a clarification or a brief explanation. So I think the bright line is you can't make a decision on something that somebody raised it because it wasn't on the agenda. And the common sense thing that's not in the statute, if you will, is that, like we mentioned earlier, arguing back and forth is a way to just have the meeting go off the rails. But
yeah,
some brief explanation. Here's what we're thinking when we decide this is permitted by the statute.
And I think it really depends on, what your goals are as a board for that particular association. We have some clients where it gets out of hand in terms of the back and forth, the meetings never get done. But I think one of the best ways to curb that, if that's what the board would like to do, is to make sure that everybody knows well in advance, here's the policies for the meetings, here's the policies for the homeowner forum, here are the expectations. And that way, if somebody gets out of line, particularly in Zoom sessions like this, you can just mute them and go on. We have a lot of clients that like to adopt, board meeting and homeowner section policies that they then distribute to the entire association so that everybody knows in advance, does not surprise exactly what happens, and then the meetings can go forward with clarity.
Yeah.
You also develop a knack over time between distinguishing between the backbencher naysayer who wants to play gotcha and criticize everything you do, and the person or group of people who have an issue-specific, legitimate query as to, obviously you guys are on the board, you know all the detail, you know all the background, you know all the stuff. We don't quite understand the decision. Can you tell us more? And there have been times where we have taken a comment from either open forum or an email we've gotten or something, and we've turned that into a town hall meeting 2 or 3 weeks later, where we've had maybe the accountant or the reserve study guy or somebody come and present what's going on to the association and say, here's more background and detail that obviously you didn't know, but we're happy to share with you. And then you actually, not only do you look like the hero, but you're actually doing a service to your entire community so people understand and they get on board. It's a terrific approach, but you can't do that for every naysaying backbencher.
No, and your bench of people that are positively engaged like that and wanting to learn more might be your next board member. That's a good way to kidnap them into the open seat.
Yes.
And I think, Deon, it goes back to your initial comment before that a lot of people talk about transparency within the board and the membership, and transparency really doesn't mean I'm giving you all the information. It goes back to your comment of context and clarity. I'm giving you enough information so that you know the context of my decision as a board member. And like you said, if more context is necessary, let's schedule a meeting to talk about that so that everybody knows what's going on. But I don't have to give you all of the details for the board's decision, because this is the board's meeting, not the membership's meeting.
And it often also transitions into a comment of, but we encourage you to run for the board next time so you can be, and in a positive way, not sort of in a blowing them off the way, because we do encourage those people, if they are that interested, come and make the decision when you're wearing the fiduciary hat and you have the liability. Come make that decision with us, because it's a tough decision.
Mm-hmm. Correct.
This is great. I love when you guys are talking back and forth, and I've received comments from people that are loving that you guys are discussing this. And it's not just like, here's the answer. Okay, here we go. How should the association respond if owners request an explanation of reserves / budgets at an open meeting?
We have no idea what it all means, right? It's actually a tough one. Reserve studies are very complex documents. It's a very complex budgeting tool. And it's even difficult for the board to understand sometimes, as much as it can be difficult for attorneys to understand what a reserve study is doing, saying, et cetera. My thoughts are always, I've had many a reserve analyst attend board meetings and do a discussion with the board and members in attendance about what the reserve study means, how it works, et cetera. That can be extraordinarily helpful, because the reserve study or the reserve budget is a very unusual budget for any type of entity. And most folks don't understand what their intent and what their purpose is. And so engaging with your reserve analyst to have them attend an open meeting and speak to the board and the membership at the same time can be extraordinarily helpful in understanding what it all means and what it does and what it doesn't do. Right, because that's another big element. We work with a lot of high-rise communities. There's many parts of the high-rise that are not included in the reserve study. And making sure that members are aware that, gosh, when we do a repair to the building, for example, the cost of scaffolding is not included in the reserve study in the plan. So being aware of its shortcomings or the items that are not always included, and then also, having a professional there to help explain can be extraordinarily helpful, not only to the board, but to the membership.
Yeah, sometimes you get big changes in the reserve study. Something has to be added. For aging communities, you may have a big maintenance thing that wasn't in there because the reserve study only looks 30 years out. But now your community is approaching 50 years and you have to redo the sewer laterals, or you have to rebuild all the balconies. And that didn't need to be in the original reserve study, but you have to add it now. And our reserve study contributions go up. That means our assessments are going to go up. And dear membership, here's why.
Mm-hmm. Yeah, and having that professional there to help explain all of that. And the other part too is a lot of reserve analysts can help the board with all sorts of budgeting, like Michael's speaking to, you're adding something new or thinking about adding something new to the reserve study. Working with that professional can be very beneficial for the board in helping to explain to members, how did we get to this cost? Why is the assessment going up this much? And having that information available, not only for the board, but the membership, can be extraordinarily helpful.
Sorry, I am fielding things. I'm going to read, we got a question in the chat that we are not going to have you guys answer because it was a direct answer, but I'm going to read it so everyone who is watching the recording knows what was said. The question was, considering the current environment, can an owner decline to rent to a Section 8 prospect? And the response in the chat says that this concerns the owner and not the association. Owners must comply with rental restrictions in the governing documents / civil code. So our next question is, and this one's another long one, my apologies. What does the civil code state regarding rental restrictions and permitted ratios of rentals to non-rentals in the community ? And can the association require an owner provide CC&Rs to renters prior to moving into the home?
Well, I'd say yes. As to the second question, yes, it says most governing documents say, or hopefully they say, the owner shall provide a copy of the governing documents to the tenant. Now, whether they do it or not is always a tough one, right? And can we compel? And would we spend money on an injunction, a lawsuit, trying to get them to force that owner to provide it? That might be an extraordinary waste of association resources, but absolutely the governing documents can require it. I think even a rule could require that owners provide the governing documents to tenants.
I agree. And I think this issue is largely evolving away from a problem to a solution, with the more that we have association websites and posted documents on websites where an owner can just give the tenant the link and say, here's the documents. It's far less burdensome on the owner. It's far more accessible to the tenant, and it's much easier for everyone to see it because they're bound by the CC&Rs, whether it's in the lease or not, or whether they got the documents or whatever, they're bound by it. So the more and more associations that are doing the websites and having access to these governing documents on an easy process, the more this issue is going away.
Yeah. And then as to the first question, so the question being, what can the ratio be under the civil code? If you can cap the number of rentals at 25% or more, right? And so you can't go below the number 25% of the properties being rented, the homes being rented. But you could always go higher than 25%. There's nothing violates the law there, but generally 4741 of the civil code says you do have this floor, and the statute says it's a reasonable restriction if it's 25% or greater. And so you could cap the number of rentals in a community at 25%, just being mindful that it wouldn't apply to any of the current owners, right? And so that's a forward looking. If you always have to keep in mind the recorded amendment that says there's a cap on the number of rentals in the community at 25% is always forward looking. And so if somebody owns on the day that document's recorded, it would not apply to them. It really is looking to apply to future owners.
And then there are issues now with the new law as far as owner occupied rental situations as well. So.
Yeah, and so.
Not to mention how ADUs mess with the ratios.
Correct, because they're not counted in.
So we're gonna go with Michael's comment, it depends.
Yeah, and the key thing I'd say too is if you're looking to do a rental restriction like that, definitely talk to the association's attorney about what can be done and how we can do it right. Because you don't want to make a mistake on this. And it can be, there's lots of considerations for the board in deciding whether or not to cap rentals, including the cost of enforcement.
Thank you. Okay. Is it okay for the board to take notes about open forum comments and include its response to the owner in the next board packet?
Absolutely. And that's kind of what I was talking about earlier was, the board or management can always be taking notes during open forum. And, If necessary, respond after the fact or respond at the next board meeting. I think that's really helpful, and it actually kind of builds transparency, right? We heard you and we thought about it and we came back and told you our thoughts. And I think that's really helpful, because the biggest problem that you run into is, like Deon's saying, you know, somebody looking to play gotcha. You know, I'm going to show up to the board meeting. I'm going to show how smart I am, and I'm the best person in the room, and I'm going to prove those directors wrong. Well, this actually seems like a good tool to avoid that. You know, we may not have the answer tonight, but we'll have it next meeting.
Or somebody brings something up the board hadn't talked about before, and maybe the board requests that the manager put that on the next agenda. Well, that's a good idea. Let's talk about that, and we'll form a committee, and the homeowner who raised the issue might get drafted to be on that committee.
He'll chair the committee, right? No.
The thing I'm cautious about with open forum, and the thing I wouldn't say I don't like about it, but I'm cautious about it, is I keep wanting to try and remind members that open forum isn't the only and probably isn't the best avenue for them to direct communications to the association, because there's so much going on at a meeting. They have abilities to ask us the same questions in writing. I don't want to discourage open forums in that regard, but I do want to encourage board members to understand that don't think this is your only, and it's probably not even your best place for you to do this, because we will give you better responses if you send us an email in writing, and then we'll be able to think about the answer and get back to you.
Nope. And I'll just say, think about the answer and get back to you and respond, right, with the response. And so I don't know what happened there.
Well, and then with that process, you don't have to wait for a full cycle for the next meeting. You can put it on the agenda, hopefully, if it's enough time, for the upcoming meeting, and discuss it then. You don't have to postpone it and put it off and wait for it. So
yeah,
absolutely.
Agreed.
I will keep watching for Deon to come back. Technology sometimes is fickle. We all know this.
Yes.
And I'm going to go out of order really quickly and tackle a pool question that came in first. Question about pool safety. Oh, 1 second, everybody. We have another attendee that got dropped too. I wonder what happened. Question about pool safety. Gate keeps being propped open. Is there a specific civil code that requires an HOA pool gate to be closed and locked, or can the association adopt a rule?
They're typically building codes that require it to be locked. And so in this, absolutely, the association could adopt a rule to mandate. As a matter of fact, I just wrote some yesterday, saying that the gate to the pool will remain locked at all times, and leaving it ajar is a violation of the rule, or propping it open to allow access.
or climbing the fence to jump in.
Yeah, actually, we have that in every rule too. You can't climb the fences. So and you can't jump from buildings into the pool. But you know, as a kid, I always did that, but it seems like a bad idea these days.
You didn't live in an HOA though, right?
No, that was a high school swimming pool. You know, you go to the roof, jump off of it. Good times when you're a kid, but terrible idea.
Burning to tell her story now.
So, but yeah, absolutely adopt rules saying you can't keep because what is the big risk, right? I always joke that, you know, basically your swimming pool is a loaded gun in the common area, right? It's just waiting for that day when something bad happens. And so getting ahead of it, making sure that we have rules that protect folks' safety, making sure that we have all the notices in our rules about no lifeguard on duty, that it's recycled water and you should not drink it. I mean, they're kind of goofy rules that we put in the pool rules, but they're important because it kind of reminds folks, hey, yeah, don't drink the pool water, even though that should be obvious to everyone. We have a law that says it has to be on a sign outside our pool, and adopting rules that say you can't leave the pool ajar or the gate ajar to the pool or prop it open is generally the best practice. And if you can afford it, having a pool monitor is also extremely helpful to ensure that gate is not propped open. No matter what rule we adopt, somebody may still do that. And having the person available to be monitoring the pool and ensure the gates are locked is just an added layer of protection for the community.
Yeah, that addresses what I was going to chime in on, is we can adopt a rule that you can't prop the gate open, but we have to be realistic that enforcement may be difficult. You came by and found the door propped open and we can't prove who did it, so we don't know who to call over here.
Yeah, and just remembering a pool monitor is not a lifeguard. You know, we all see the headlines these days about how hard it is to find lifeguards. I know Deon and I have been out working as lifeguards at pools lately to make some extra money on the side, but they're just really
Their
hard to
numbers
come by.
are.
Yeah, exactly. We drink margaritas while we're being lifeguards. No, but yeah, having a pool monitor, which is less than a lifeguard, right? Somebody that's there just to observe and ensure the safe use of the common facilities, but not serving as a rescue, CPR trained, et cetera, is oftentimes a great benefit to the community to ensure safe use of our pool.
Well, since we don't have any other questions, one little perhaps caveat while we're talking about pool rules, if you guys would like to discuss, is this is where we see a lot of our potential fair housing violations as we're going through our various pool rules. If somebody wants to jump in and
yeah, and then adopt a rule that says children under 14 can never use the pool ever in their life.
definitely, yep.
Yeah, that's a dangerous rule, I think. And I know, Daniel, you've probably dealt with that more than you want to think about, I bet.
Quite often, yep.
Yeah, and so one of the big things, you can get into housing discrimination disputes quite regularly if you adopt rules that restrict children and families. If you're restricting play, as I like to say, right? Children that live in our communities have a right to play. And there was a trial court case years ago that talked about, you know, what is the purpose of these rules is to protect persons from drowning in the pool, right? And the court in that case, you know, the board had adopted a rule saying no child under 14 can use the pool without an adult being present. And in the lawsuit, the plaintiffs in the court agreed that, you know, there can be children that are 14 that can swim better than I can and could probably work as a lifeguard and rescue me, an old man, when drowning in a pool. And so the 14, the age limit doesn't have anything to do with it. It has more to do with skill and ability to swim. And so you're always, when you're thinking in housing discrimination, you always have to be thinking about what's the least restrictive type of rule that we can have and still accomplish our goal. And so that's one, when you're thinking about it, absolutely speak to your attorneys about it and work through the issues, because the fair housing risks are everywhere when it comes to those types of recreational facilities.
And we see it outside of the pool context. You know, there's rules of, you know, children cannot play in the streets or ride their skateboard. No, we make that nobody can ride their skateboards in the street, because we know that, you know, Darren likes to go out and do that.
I actually have 4 longboards. Just so you know, I used to skate quite regularly, but again, you get older.
Skateboarding is not a crime, but it might be a rule violation.
No, skateboarding is never a crime. It's only until you break things that it becomes a crime, right?
Right.
I got a direct message comment in regards to this topic really quickly. And I think that what they're asking is a specific code for the gate for kids, but I asked for clarification.
Oh, it's California Code of Regulation. It always takes about, what, 40 minutes to find those, Daniel? Is that right?
Yeah, at least.
When you read the Code of Regulation, you're going to find out what nightmare regulators can create.
Yeah.
And it's part of the building code, and it's in the swimming pool section, which I think is like Title 27. Anyways, it takes time to look it up. I don't have it memorized. I'm sorry.
Yeah, but it's not in the civil code. I think somebody asked.
No, it's a code of California Code of Regulation, which oddly enough stands for CC&Rs. The California Code of Regulation is where you find that.
The coworker says Title 24 there in the chat.
Oh, it's 24. Okay.
We'll trust her.
All right, next question. Thank you guys. Can gates in a community be locked from the inside so that you would need a fob or a code to get out of the community? Is this a fire or emergency hazard?
I'm sure it is.
Yes.
Yeah.
Are they talking about the vehicle gates? I think that'd be a terrible idea that you need a clicker to get out the vehicle gate.
I think pedestrian gates. That's what it sounded like.
I'd love to know why we would want to do this.
Yes.
Yeah. Either way, you can't lock people in if there's a bad thing happening.
Because it's not an association, it's a jail.
Right.
Sorry. No, I mean, it just seems, I can't imagine a fire department, because that's generally who would be concerned about this, would be your local fire marshal. I couldn't imagine that they'd permit that.
Okay,
And I'm
thank you
sure
very
the
much.
Code of regulations might have stuff about permitting egress in the event of a fire and stuff like that.
Yeah,
That being said, we do have some, these rural communities that have these fire access emergency exit gates that are only allowed to be used in an emergency. So they're not regularly somebody can go out of, but in an emergency, they're designed with a breakaway so you can get through them with your car, but we're not obligated to leave those open for non-emergency purposes. But those are sort of a unusual, unique situation.
yeah,
Yeah, and that's never going to be the primary method of egress.
Correct. And then
Yeah.
all the other places you can get out.
correct.
Rachel, I had a sort of do you have other questions lined up? Because I had one that sort of evolved when we were preparing our presentation.
I have two questions, but go ahead.
No, go with yours and then we'll come back to mine.
Okay. What is the best way to handle a rogue board member?
With kid gloves.
Well, it depends. It depends in
Yeah.
what way they're being rogue, right? If they're being rogue in disrupting board meetings, we hold board meetings by Zoom mostly these days. And I would say to him, if you're going to continue to be disruptive, we're going to move you out of the board meeting and you can take us to court, because we're going to record these board meetings. And we're going to have a record of all the times you've been disruptive. We're trying to conduct our business. You are a fiduciary, and bring it on. If they're being disruptive in the sense that if they're being a rogue, in the sense that they're not keeping executive session information confidential and they're blabbing it, my answer is we're creating an executive committee, a committee of the board made up of all board members other than you, and we're going to delegate every executive session item to that committee, and you're out of the picture until you can show us you can behave again. So there's different methods to deal with different types of rogueness.
Correct.
And there's
Oh,
probably
sure.
five other kinds we can think of, right?
Yeah,
Yeah.
kicking them off the board, which is a question we get quite often, is difficult. That usually requires a vote of membership.
Yeah, and and recall votes are often unsuccessful, especially when the board's trying to recall its own.
Yeah, that's a bad look.
Yeah, it really is. It's quite undermining. The other thing you can do too is I always find, because it is, being a rogue director, there's an argument that it's a breach of the duty of loyalty, right? One of your fiduciary obligations is loyalty to the association above all else. And there is a conversation to be had with the board and perhaps the association's council about how this conduct and behavior is actually a breach of duty. And that the directors failing their obligations to the community by doing this, right? This is not the state legislature when you're serving on a board of directors. This is a different relationship, a higher standard of care. And sometimes explaining that to a director who feels that either they're not being heard or they're not being recognized or they disagree with what the majority is doing, helping them to understand their role as a director is not to be a political actor, but to act in the best interest can be extraordinarily helpful for everybody on the board.
Yeah.
So sometimes training can help, working with council, working with the directors, management, the whole team of professionals can really sometimes turn those situations around, or sometimes like you have to do the extreme option that Deon discussed, where you form a committee of the board that excludes that director so that business can be conducted.
The other approach I've used that has worked surprisingly well with adults, because I didn't really think it would, we developed it with kids, right? And the approach we developed when we were coaching soccer is often when you had the most difficult kid on the soccer team, just the one who wasn't the go-along kid or whatever, you make them captain. And all of a sudden, they take on this mantle of, I got a different role, and they shape up. And I've had some associations that as soon as the rogue director gets on the board, they make him president. And some of those guys have become some of the best board members I've ever worked with, because they were immediately made president and given an opportunity to act as a leader. And it failed a few times, admittedly, but more times than I would have guessed for adults, it has worked.
And I actually want to take I wholeheartedly agree with that. There are situations where you need to go the other way. And I think it's a good clarification from what Michael said, that removing a director is incredibly hard. But what if the rogue action is you've got a president who thinks that as president, it's my show and it's not the board's show. Removing an officer title is easy. I mean, that's simply a vote of the board. So if you've got a president that's going around saying, as president, I'm approving this, I'm saying this, I'm doing this, and we work with those that do that.
I'm firing the manager unilaterally.
Right. The board can get together and say, well, as a board, you know, we've discussed, you're no longer president. We're appointing this person and you're director at large, or you've got another position of responsibility. And here's why we're making that decision. Yeah. So sometimes you have to go the other way as well.
Agreed.
Mm-hmm.
All right, we have 2 questions in the queue. This one's long again, so if you need me to clarify, please let me know. We have a small group of adjacent units who smoke. The smoke drifts into common areas and other units. The board has sent smoking reminder letters to all. However, some units continue to allow smoke into common areas. How can or should the board respond?
I think it depends where you're at. We've got some cities and some locations that have a complete no smoking ban. City of Pasadena, no smoking anywhere in the association whatsoever. And some that don't have anything like that. So it depends where you're at, what your docs say.
And I think it's just like any other compliance matter. It's a matter of sending letters to those owners, advising them of the issues. I'll tell you, I wrote a letter. My favorite one I ever sent recently was I sent a letter exactly addressing this issue. And I got a letter back from the owners saying, you know, smoking is not that bad. I don't understand why you're complaining about it. Which was kind of a curious response because I'd never gotten that, right? Oh, smoking is actually good for you. We should all start. You know, so you will get different responses, but usually it's you go through the ordinary compliance process, right? I'm a big fan as well. If you don't get compliance, fines aren't working, is maybe looking to meet with the owner in IDR. Through an internal dispute resolution meeting with the owner to find out why is smoking so prevalent. I get it's an addiction. I get that you can't give up that addiction, but at the same time, there must be something that we can do or that you can do in particular, owner, that would help to alleviate this smoking condition. Because despite the homeowner that wrote to me saying that smoking is not that bad and we all should start doing it, it still has been found to be a carcinogen and actually kills people quite regularly, unbeknownst to that owner. So keep that in, the IDR process or even mediation, because, a lawsuit is expensive, costly, and time consuming, but trying to work with our membership either through the ordinary compliance process, if that doesn't resolve it, perhaps it's an internal dispute resolution meeting or even an offer to go to mediation with a third party neutral, if appropriate, to see if there's some way that we can resolve this ongoing issue.
The interesting twist I've seen on this one in the last, 5, 6, 8 years was the person who's smoking marijuana, and particularly before it became legal, and then they had the medical card to smoke marijuana, and even now that marijuana is legal, and they say, you can't prohibit me because it's legal, and we have to have the discussion with them. Simply because something is legal doesn't mean we are prohibited from regulating it within our HOA. And so they thought they had a free pass when they could get a medical card or marijuana became widely legal, but it isn't the case. It is exactly like a cigarette. So
or the paint on a home, right? There's no law that says I have to paint my home a certain color.
Or
every set of governing documents say you have to go through an architectural approval process. It's the same concepts.
Yeah, or playing your music at 110 decibels is legal, but it's still a nuisance to your neighbors.
Correct.
Thank you, guys. Okay, one more question that we have in the queue. Follow-up question to the pool discussion. What can the association do if non-residents access pools and spas by climbing the fence?
Build a better fence.
Well, cameras these days.
Yeah.
These days, cameras, because it makes the enforcement and fining much more documentable. So I think definitely that.
Yeah, and if it sounds like it's somebody from outside the community that's climbing the fence and swimming, is that correct? And in that circumstance, we might want to think about a patrol service, the private patrol guards, perhaps a pool monitor to be there to observe, right? Keeping the gate closed is helpful for the pool monitor, but monitoring and seeing someone climb the fence and then calling, obviously you might have to call law enforcement in that setting because it's likely a trespasser. We don't want our guard or our pool monitor getting hurt. And usually that would be a phone call to law enforcement with somebody, in essence, trespassing into the common area who doesn't have a right to be there.
And, on those issues, when you're calling law enforcement, because that's what I was gonna say, it's trespassing and you can call the police or the sheriff. And they may not catch the person that night if it's a group of teenagers that are coming to your pool, regularly. But I have had community liaison officers tell associations, look, call us. We won't catch them right then, but you may get heightened enforcement if you're calling us, every Friday night, the same group of teenagers is hopping the fence. We'll have somebody come by on Friday nights and you'll get heightened enforcement in your area because they're getting more calls, even if they didn't arrest anybody the first or second time you call.
Rachel, did you want me to throw my question out there? Or
Yes, we have another question, but it's being reviewed. So yes, please throw out your question.
So the question I had sort of dovetailed out of our earlier conversation an hour, 2 hours ago. And I think everybody on the calls, it has to deal with, what takes precedence, the rules or the CC&Rs or the statute. And our general rule is, if it's in the rules, it has the least authority, and all of the governing documents, bylaws, articles, CC&Rs supersede the rules. But recently, we're telling people, if stuff is in your election rules, that takes control over contrary stuff in the bylaws, because the statute authorizes the election rules to override the bylaws. And so we have a sort of double override here. And so people are looking at they're saying, but my bylaws say that you have to be in good standing to vote in an association election as a member. But my election rules say we don't, and you're telling me we have to allow delinquent owners to vote. And the answer is yes. So your election rules can contradict, and in many cases must contradict your bylaws if it's in order to be consistent with the Davis-Sterling statute. And so it's confusing hierarchy exception. So
it almost circles back around because the civil code says your election rules have to have this. So since the civil code requires it, that supersedes the bylaws. So you put the rules in, but since it's the civil code, it supersedes the bylaws.
And our ladder falls apart, right?
Right.
Well, I would argue it doesn't. That in essence, the rules are just stating what the law. The law is what trumps or prevents the enforcement of the bylaw provision, and then the rule is just stating what the law says. Right. So that's the way I see it. I don't see it as because remember, Deon said it's the what did you call the rules, the lowest priority? And I'd say, well, rules the courts have always ruled that they're just as enforceable as the CC&Rs. So be aware.
They just sit on the lowest rung on the ladder.
Yeah, and they're the easiest to change because only the board has to vote to change them, right? And so or adopt them.
I always point out that the default assumption is the easier they are to change, the less authority they have. In the case of a conflict, right? They're perfectly enforceable. But if the civil code and the CC&Rs and the bylaws and the articles and the rules conflict, the harder it is to change, the more authority they have in that instance. But as always, the bottom line is your mileage may vary, and invite your friendly community association lawyer to the next meeting to read your governing documents and explain it.
Yeah, fair enough.
Thank you. Okay, one more question. Can an HOA stop or ban smoking on one's balcony, which is not common area?
Yeah, I think you absolutely can. You could ban, again, unbeknownst to the owner who said smoking's cool and we should all take it up. You can ban smoking, especially in a condominium. And I don't think you'd have a court in this state or any other state probably that would say that's unreasonable, because it's carcinogenic. And so, I always like when we're adopting smoking rules to list off in a resolution of the board, listing off the reasons why we're doing it. There's a health risk to every owner in the community, and we cannot prevent that health risk except for through the prohibition of this tobacco product. or whatever it might be, cannabis, tobacco, whatever. And I think that those things help to support any arguments, because you will get these owners that say, oh, smoking's great, we should all be on board. But at the same time, no court's going to see that as reasonable or fair to the neighbor who maybe has a health condition, right, that's affected by the smoking, or whoever it may be that could be impacted by that smoke. It's not just a nuisance, it's a carcinogen, something more, something worse.
Exactly. And if somebody's
This
smoking,
question, oh, sorry, go ahead, Mike.
I was gonna say, and if somebody's smoking either inside the unit or out on the balcony, if they're interfering with the neighbor's use and enjoyment, it's a nuisance either way. It doesn't matter where the smoking person is sitting in that sense.
Correct.
The question itself is a great illustration of how the world evolves in HOAs particularly. When I was a young lawyer in the early 1990s, we had an association in Sacramento that tried to ban smoking in the clubhouse. And we had a full-blown lawsuit on it. And we had people submitting declarations as to how good smoking was and how nice it was and everything. And the association said to me, do you think we have the right to it? I said, I think you absolutely have the legal right to. And we actually ended up settling the lawsuit. And so we didn't have a court ruling. But I said, I don't think you have a hope in hell of ever having an enforceable rule or CC&R prohibiting smoking in the individual units in this day and age. I said, I think it might be coming in the future, but we're not there yet. And I'm happy to say, like literally 30 years later, it's like a no-brainer now.
Yeah.
It's like, we didn't even hesitate to say that's enforceable on the balcony or inside the unit.
Yeah.
Yep. And it used to be
Things
people smoked
change.
on airplanes, right? I mean, remember that.
But only in the smoking section, Darren.
Yes.
We were in the non-smoking section.
We were just fine up front and everybody smoked in the back.
All the guys with white hair remember walking into restaurants being asked to, smoking or non-smoking.
Yeah.
Yep.
Yeah, it is amazing to see the evolution. I mean, like Daniel was talking about, Pasadena, there's no smoking anywhere. Whole cities prohibit smoking. Indoors, outdoors, anywhere.
Within the specific unit, anywhere. Yeah.
Yeah.
Yep. So
I might have another question coming in. And I just got a question, but it needs to be fielded by our resident. Shout out to Rachel Solomon, who is fielding these questions, because I love her. Anyway, but in the meantime, while we wait for that,
can I say something while we wait for that? These questions have been awesome.
Yeah,
These
they really
questions have been absolutely awesome. So sometimes we do these Q&A things and people hone in on these esoteric things, and the question itself is 10 minutes long and nobody else cares about the answer. These questions have been relevant, they've been current, they've been insightful. So thanks this has been very enjoyable for, I think, all of us on the panel here. So
Absolutely. Yeah.
And now Deon's going to ask an esoteric question.
Right.
Yeah.
no, we have one. Okay. How do you stop someone from smoking inside the four walls of their home?
Well, is it a home as in a unit in a multifamily community, or is it a home as in single family?
For the purpose of this, Darren, let's assume it's a worst case scenario, single family home.
Yeah.
Let's go with that.
How would you do it on a single family home? How would you ever know there's smoking in a single family home?
Yeah, I think you adopt the rule, and then if somebody has a violation that they report, then you have to do the same thing you would do with any other violation. You would document it and be sure that you can document it for it. You'd call them to hearing. You would fine them. If fining doesn't change behavior, you might ultimately have to go to court and get an injunction. It's the same thing. It's the same as every other enforcement we talk about. Just the gathering of the evidence is the more difficult part.
Exactly. Yeah. If they're smoking in the home and nobody knows. But if it's blowing out of their window and right into my kitchen window as I cook dinner every night, now it's a nuisance, and we call them to a hearing and that process.
The
Yeah,
way
and
Mike cooks, though, the smoke.
And so I noticed in the comments, it says it was in a townhome, so it's attached walls. that, yeah, it's easier to document and prove, right? What's the first step when a violation is reported is investigate. Can we verify the complaint? How are we going to verify the complaint? And in a townhome, I think you're in a where you have connected walls, it's going to be much easier because the person living next door is most likely the person making the report, or persons living next door. And so that's typically what you would do in that process is gather the information, speak with the owner that's making the report, and then talk to the owner that's reported to be smoking and see if we can find resolution to it and work through that issue.
We just got a new question. I think that I can just read it, but I need yeah, okay, thanks. Okay. Can the panel comment on right to a view concerning trees? What is considered a reasonable view?
I'm not going to comment on it because it's so fact specific. One, do you have a deed restriction that says you have a right to a view? That's the very first question. In California, there is no right to a view, unless there's something either in our CC&Rs or some other recorded agreement that says that there is a view right. The rest of it is all a nightmare that will result in a lawsuit that'll cost you a small fortune. So
Is the subject of probably half of the pending cases in the Marin County Superior Court. Every time I go to court there, it seems like that's all the cases.
And 0 in Sacramento because we're all flat. But for whoever asked this question, there's an instructional case, and I don't remember the name of the case. It's the one with the Marquesa. It's the Marquesa case, Ekstrom versus Marquesa. Look up EKSTROM versus Marquesa, MARQUESA, and that's a case what dealt with trees and views and a board that significantly overstepped its line in trying to adopt rules to make to prohibit people from
removing palm trees, right?
Yeah, but it was a view that was guaranteed by the CC&Rs, and the board didn't want to enforce it. But the case does say there's no inherent right to a view. That's absolutely correct. But it's a great case to read on a whole bunch of facts.
Check the chat. You've got the full link there. The full name.
But remember that case deals more with the board of directors' decision to make a convoluted rule to protect certain trees within the community. And if you're talking about what's a reasonable view, that is the most difficult one. I've litigated that at least 3 times now. It is a very difficult issue because what is reasonable? Right. And that's a judge is going to make that call, or a jury is going to make that call. What is reasonable? My idea of reasonable might be completely different from Michael's idea of reasonable. And Daniel may have a completely different idea, et cetera. Sure. And so it is a very difficult matter. And it's one that I would definitely speak to your attorneys about, because the view lawsuits are pretty brutal for the most part. And if there's
no winners there.
There really is. Nobody gets out going, woo, I got everything I wanted. And what I would suggest is, when I always suggest on view ones, is let's try to find some alternatives to a fight, to a lawsuit.
One of the interesting things that we're seeing really quick before we finish up, especially down in Orange County, is that you've got city municipality codes that are now going across the board on what they will require as various view rights outside of the CC&Rs, and how those apply, and they might not apply depending on the CC&Rs. So even when you're not in Sacramento, when you're down in Orange County, talk to your attorneys about this one, because this is one that can explode and get very, very messy very fast
and very expensive, which the association is not budgeting or planning for.
Very expensive. I mean, I mentioned all the Marin County cases. It's always one neighbor, I like the trees, and the other neighbor says, but the trees block my view of the Golden Gate Bridge. And they're both very wealthy, and all the lawyers make lots and lots of money, and the case drags on forever. And
so I guess there are some winners.
Right. Yeah.
There are. Yeah, and all your kids got to go to college, right? So
they did.
All right, guys. Well, it looks like we are out of time, but I would like to give a big thank you to all of our speakers. We appreciate your guys' time so much today. This is my favorite part. I love when you guys are just, I know Rachel mentioned it earlier, but a question comes at you and you guys just kind of banter back and forth and give your opinions and thoughts. And that's always my favorite part of it. I would also like to give a big shout out to Senior Associate Rachel Solomon of Nordberg and DeNichilo for helping us field the questions today. A big thank you to Rachel for running this whole program. I don't know what we would ever do without her. And that's a wrap on our 2-day board leader course. So thank you to all of our attendees. Thank you to our sponsors, to our speakers. By the end of the day today, you should receive your $5 Starbucks gift card. Again, thank you to the sponsors for that. And your certificate of completion should be in your email within about a week. Please keep an eye out for our survey. Your feedback is very important to us on how we handle these events in the future. We want to hear back from you. What did you like? What did you not like? What would you like to see more of? What would you like to see less of? And we hope to see you guys at another A Chapter event this year. So thank you guys very much.
All right. Everybody have a great afternoon. Thank you.
Yes.
Goodbye.
And if you're in the Sacramento region, try to stay cool. Remember to hydrate. So
Yes.
Yes.
Thanks all. We'll be sending you the attorney's information with the follow-up email. Bye.
Bye.
bye.